The Endangered Species Act, or the ESA, allows citizens to sue federal agencies if they think the act is being enforced improperly. Typically, this involves citizens protesting the harm done by failing to protect species sufficiently, but it doesn't have to. In Bennett v. Speer, the United States Supreme Court considered whether citizens who thought the act was being enforced too much also had standing to sue. The Klamath Irrigation Project in California and Oregon is a series of lakes, dams, and irrigation canals created by the Bureau of Reclamation early in the 20th century. In 1992, the Bureau of Reclamation notified the Fish and Wildlife Service that the Klamath Project might adversely affect 2 endangered fish species. The service issued an official statement called a biological opinion, concluding that the Klamath Project could jeopardize these species' long-term survival. It recommended maintaining minimum water levels in 2 reservoirs. 2 Oregon irrigation districts that used water from the Klamath Project and the operators of 2 ranches in those districts, one of whom was Brad Bennett, filed an action against 2 directors of the service and the Secretary of the Interior, protesting the measures proposed in the biological opinion. The district court found that the irrigation districts and ranchers lacked standing because their recreational, aesthetic, and commercial interests in the waterways didn't fall within the zone of interests protected by the ESA. It dismissed their complaint for lack of jurisdiction. On appeal, the Ninth Circuit held that only plaintiffs who alleged an interest in the preservation of endangered species fell within the Act's zone of interests test. The court also held that Bennett wasn't entitled to judicial review under the Administrative Procedure Act, or the APA, because the biological opinion didn't constitute final agency action. It affirmed the dismissal. The United States Supreme Court granted cert.